Hi, I'm Geoffrey Gieseler, Managing Attorney of PLFs Atlantic Center office here in Stuart, Florida. America's Constitution requires states to pay property owners just compensation whenever they take away their property rights for the use of the public. But when a state's judges simply declare that a person's property never existed in the first place, that question is left somewhat unresolved. For decades, states have escaped their duties to pay for takings by having the courts, rather than legislatures or executives, do the dirty work. That's the issue that the United States Supreme Court will be considering on Wednesday, when lawyers for a group of Florida homeowners asked justices to reverse a decision by Florida's highest court that suddenly and retroactively eliminated the property rights of beachfront residents. So drastic was the state court's departure from settled Florida law that it erased constitutional protections that shorefront owners had relied on for almost a century. The case began when property owners challenged a state law that created a program for renourishing beach property by adding sand to the beaches to counteract erosion. The beaches in question weren't in danger of eroding away, but because the law contains no standards for determining when a beach is endangered, city officials simply declared the area's beaches to be in need of this renourishment. That decision was important because the renourishment law automatically readjusts a property owner's boundary line, cutting off the owner's right to access the water, the right to an unobstructed view, and other rights that have belonged to waterfront owners in Florida for centuries. Now, normally, property owners in these cases would get their compensation after filing a lawsuit challenging the constitutionality of the city officials' actions. But the Florida Supreme Court in this case refused to compensate the property owners. Instead, the court retroactively erased their property rights, and then held that since those rights didn't really exist in the first place, the state couldn't have taken them. Therefore, the state owed no compensation, and with a stroke of a pen, these state court judges allowed the state of Florida to seize beachfront property without paying for it. Federal judges are usually very nervous about intruding on the power of the states, preferring to trust state judges to handle most issues of property law. Likewise, the United States Supreme Court's reluctance to intervene in such cases is understandable. But now that the Supreme Court is confronting this issue of judicial takings directly, property owners must hope that the justices will rein in state court abuses. On Wednesday, we shall see. PLF is proud to be the author of the only friend of the court brief urging the Supreme Court to hear the case, successfully obviously. You can find that brief along with the others in the case and all the other information you'd want relevant to Wednesday's argument at our website, www.pacificlegal.org. I thank you for your time and for your support of Pacific Legal Foundation.